Now, I do a little bit of digging, and we're ready for our next. Tom, can you go ahead and they're going to put the mic on you back there. And go ahead and get your mic put on. So, I'm going to ask, could you come up here for me and sit right here in this front seat with me? Yeah, come on up. Sure. That's a special hot seat. We got a special surprise for you. That's some point. There we go. So, running around town again, I get to meet some really fun people. It's just kind of a neat thing that I'm very fortunate. People say, how do you feel fortunate to have gone through a coma and that's a terrible situation, but it gives you a different perspective on life that really helps you understand what's important. And gosh, we've got some great people who really help us to understand that, right? Running around town and being a graduate of St. Louis University, shout out to any St. Louis University graduates also, SLU, right? I decided to go away for school, so I went 25 minutes down the road, lived on campus, and parents said, you're going to learn a little bit, you're going to live on campus. That was a mistake, they might say no, but I had a lot of fun. But that's where the story got set forward. But I graduated there. As a graduate at SLU, you can't help but meet some of the best attorneys in the Midwest and in the country. St. Louis University Law School is incredible. And so then I met a bunch of friends and baseball buddies. So one of my closest lawyer friends, I said, man, I need to have one of the best divorce attorneys in the country. Find one for me. I need him to be a speaker at our next event because it's such a big issue in our culture today. And so many people, I think, get misguided with it, and they're afraid to ask the questions. And what if we had an expert come up and talk about that? Offering, he didn't charge us to be here, so that was nice, right? The lawyers are very expensive. And so we appreciate it. If you would, give it up for Mr. Tom Karsten.
Thanks. Good evening, everybody. Is this working okay? Can you hear me? My name's Tom Karsten. I'm an attorney at law here in Clayton, Missouri. I've been an attorney since 1999. I have kind of an unusual career trajectory. I had a childhood obsession with Brazil, and I moved there at a very young age, right after law school. I worked for an international law firm in Chicago, doing mergers and acquisitions for many, many years. Ended up coming back to St. Louis in 2005 and joined the firm of some friends and colleagues of mine from law school. Been practicing with them for the last 15 to 20 years. Each of them in the last year or two was appointed by Governor Parson as a judge. Jeff Medler in St. Louis County, my other partner David Reuther in St. Louis City, and left me as the senior managing partner of the firm. It's a general practice firm, so we do just about anything that comes in the door, but my particular specialty is family law, which involves divorce, child custody, child support, paternity, and I do a lot of estate planning and probate administration for decedents' estates, wills, trusts, guardianships, that sort of thing. But Carter asked me to come and talk tonight about divorce because it's something that pretty much impacts everybody. Statistically, it's 50% chance that if you're married, you're going to end up divorced. So it's something that affects not only all of us individually, but if not you yourself, probably somebody that you know or a loved one. And it's one of my specialties. It's not something that I necessarily dreamed that I would become a divorce lawyer. I got here to St. Louis, and that's what we did. I got very good at it. I specialize in jurisdictional conflicts and a lot of post-dissolution divisions of things like pensions. But I'm here to talk generally tonight to try to demystify the law in Missouri about divorce and the divorce process so that hopefully you all leave here with some knowledge about how the process works. Because one of the things that I strive for as an attorney is to make the process transparent. I don't want to be a lawyer where you go in and your lawyer says, just trust me, sign here. I try to answer every question for everybody, try to make sure that they understand what we're doing. I put clients are really in charge, right? I take my directives from my client. My job is to give them the information that they need so that they can make an informed decision and tell me what they need me to do for them. So basically, divorce in Missouri, does anybody know what you need to be able to file for a divorce in Missouri? Is it important where you got married? If you got married in Honolulu, for example, on your honeymoon, do you need to get married in Honolulu? Or if you're Elon Musk and you decided to do a marriage on the space shuttle, where do you file for divorce? In Missouri, you actually only have to have one of the parties present in the state of Missouri. And you only have to be here for a pretty short time. Does anybody know how long you have to be in the state for you to be able to file for a divorce in Missouri? Do you know? It's 90 days. That's surprising that you know. It's actually a surprisingly short time, right? You only have to be in the state of Missouri for 90 days, and the courts have subject matter jurisdiction to hear your divorce. There are only 3 possible tracks that your divorce can take. And I'm going to tell you a lot of insider stuff tonight that other lawyers probably won't tell you, so that you're going to walk away with this thinking you have a free law degree in family law. So there's only 3 tracks. Number 1 is the non-contested divorce. That's where there's no contest or no dispute between you and your spouse. That's always the best idea, right? It's the cheapest way to do it, it's the most amicable way to do it, and it's the most expeditious way to do it. But that depends on your and your spouse's ability to come to a complete agreement, a global settlement about everything involved in your divorce. And sometimes that happens. Sometimes, unfortunately, some people are not mature enough or reasonable enough to be able to come to that kind of agreement on their own. The next track is the default. So your spouse won't agree with you about what they're going to do. Maybe they're delaying unreasonably. Maybe you want to talk to them about divorce and they're ignoring the subject. So you decide, I want to move forward. I file for divorce because I've been here for 90 days. You have to have the other party served, right? That's a constitutional due process requirement whenever you take anybody to court. You have to give them notice that you're suing them. And divorce is a type of lawsuit. So you have a private process server or a sheriff come out and hand the other spouse a copy of the dissolution petition. Well, when you get handed any kind of summons on a case when someone's suing you, that triggers your obligation to respond to that in writing by filing an answer with the court. You got to do that within 30 days. And if you don't do that, you're in default. And there's a ton of people who get served with process and say, oh, well, I'm going to screw that, I'm going to throw it in the trash. They don't do anything. Well, I love when that happens because if the other party doesn't respond in 30 days, guess what happens? I get to take my client to court on a default hearing, and I get the judge to give me everything that I want, right? There's no other party participating, so it's a steamroll. The only other way that a divorce can be concluded after a non-contested divorce or a default is the most prevalent, unfortunately, and that's the truly contested divorce, where we file, we serve the other party, they file an answer, and now we're in court, and we're duking it out over all of the different elements in a divorce that have to be decided. So what are those things? Whether I come to an agreement with my spouse, or whether or not, in the absence of an agreement, I have to have a judge decide my fate, there are only 4 issues statutorily that a judge has to decide, or that you guys have to decide on your own with your spouse. Number 1, it's the division of all your property and debts. You have property and debts from before you got married, you have property and debts you accumulate during the marriage, and unless you can come to a decision about that, the judge is going to apply Missouri law and decide how to divide your stuff. Number 2 is maintenance, right? That's what we call alimony in Missouri. It's spousal support. Number 3 is child custody if you have children and visitation. And number 4 is child support and the division of all your child-related expenses. So if you can decide all those things on your own, that's always best, right? I always encourage people. I'm a very settlement-oriented attorney. It's in my client's best interest to achieve that result as quickly and cheaply as possible, but some people can't do it. So if we have to go to court and the judge has to hear these issues and vet them and maybe ultimately decide them through an evidentiary hearing in the form of a trial, we can do that. But just so you know, I'd like to talk briefly about each of those 4 things, right? So your property and debt in Missouri, anything that you own prior to your marriage is your separate property always by statute, right? There's other categories of separate property. If I give you something, even during your marriage, I like you, I want you to have a Cadillac. It's your separate property. It will never be your spouse's. Similarly, if you inherit something, my Uncle Buck dies and he leaves me whatever my inheritance is, even if I'm married, that will always be my separate property. My spouse doesn't have any interest in that. The appreciation in any of your separate property is separate. So if I own an old share of Google from before I married you in 1975, and now it's worth, that single share is worth billions of dollars, it doesn't matter. It's still my separate property. And if I exchange any of that separate property, I sell it and I get something new, it will always retain its separate character unless I do something to jointly title it or otherwise transmute it into marital property. Conversely, anything that I acquire after I'm married is presumptively marital. It's a presumption. You can rebut it by showing that it should be separate property. But if you acquire it after marriage, it's presumptively marital, and it's going to be divided equally. The statute doesn't say equally, it says equitably, but that's pretty much 50-50. So sometimes it gets complicated because you have a blend, right? Like I could have a portfolio of rental property from before my marriage, and it's all titled in my own name, and I get married, and even after we're married, if we get divorced, that's always going to be my separate property because I always owned it from prior to the marriage. But this is what really trips people up is, it's not about the titling of their assets during marriage, it's about the income that their assets generate. Because a fundamental axiom in Missouri that a lot of people don't understand is that income from any source is marital. Courts treat your marriage as an equity partnership. So it doesn't matter if you're earn $1 million a year and your wife is a stay-at-home mom, your income is always going to be treated by the courts as marital. So in the example of my separate portfolio of real estate, that's always my separate property by statute, what trips me up is during my marriage, I'm making payments on the mortgage towards all of my different rental properties. And with each payment of the mortgage and the pay down on it, I'm creating a corresponding amount of equity in the realty. And courts are going to say, because of the fundamental axiom that income from any source is marital, every mortgage payment that you make during your 30-year marriage, it's not going to corrupt the underlying title of the realty, right? It's still going to be your separate property, but the courts are going to look back and say, well, during that 30-year period, you paid down this mortgage and you created a marital carbuncle that's growing on the side of your separate asset, right? It's a blend. And so one of the most fertile areas of litigation is the characterization of your marital property. What's separate, what's marital, and what's blended. And the same goes for debts. Maintenance is an equally fertile area of litigation. In my opinion, it might be the most fertile because Missouri, unlike a lot of states, doesn't have a bright line test to determine how much alimony we should pay somebody. It's a statute that says the judge can consider a whole litany of factors, the duration of the marriage probably being the most significant, each party's respective professional qualifications, your educational background, your health at the time that you're asking for it, the payor's ability to pay maintenance. But most importantly, it's kind of a financial analysis about if I'm seeking maintenance, I want to show the court that I'm incapable of earning much, but my expenses are very high because maintenance is going to be calculated to fill in that gap. If I'm prosecuting a maintenance claim, that's what I want to show the court. My client is unable to earn anything and has very high expenses. And if I'm defending against the maintenance claim, I do the inverse. I try to get the court to believe that the person seeking maintenance is underemployed or capable of earning more because a court can impute a fictitious income to someone. And I try to show that their expenses are inflated and should really come down so that what they need is a much smaller gap. Child custody in Missouri, we have statutes that presume, there are two facets of child custody, right? There's legal custody and physical custody. Legal is the decision-making rights for your kids. Who gets to pick their, decisions related to their health, their education, the children's welfare. The statutory presumption is that we should all, as parents, share joint legal custody, so we have to make those decisions together. It's very, very hard to convince a court that one parent should be imbued with sole legal custody and get to make all the decisions, right? It happens sometimes. Maybe a parent has a history of bad decision-making, or their judgment's impaired by alcohol or drug abuse, or maybe I can prove to the court that we've tried to invite them to participate in decisions for all these years, but I can show you 2 years of emails of non-responses. Physical custody is the time that children spend with each parent. Like joint legal custody, we have statutory presumptions that say that you should share equal custody time with your children. But there are thousands of reasons why courts find that we should chip away at that. Could be the distance the parents live from each other. Maybe I'm a nighttime blackjack dealer at the Casino Queen. I can't do weeknight visitation because I come home too late. There's lots of different reasons. There's lots of different scenarios. There's no standard parenting plan for anyone. It's really case by case. And finally, child support in Missouri. You can agree to whatever you want, right? tell you the truth, in divorce, you can agree to whatever you want about any of those things, whether it's property and debt division, maintenance, child custody, child support. If you tell me what you want to do, we can put it in a form that the court will ratify. 9 times out of 10, courts love that you came up with your own solution, because then the judge doesn't have to put on his robe and come out on the bench and spend 8 hours listening to people and, their fights. So child support, if you can't agree yourself, is going to be determined by what's called the Form 14. The Supreme Court of Missouri every few years promulgates a giant matrix, and it's intended to be able to calculate what your presumed amount of support is. It's based on everybody's gross, not net income. So we're married. I have a job. I earn $10,000 a month as a security broker. You're a secretary or an administrative position. You earn $2,500 a month. We plug both of those numbers into the form. The combined ball of household income that's basically available to support that child, the Supreme Court, their little matrix you find for one child based on that amount of income is $2,203 a month. And then each of us is responsible for that in the same pro rata contribution that we made to the whole. There are some adjustments in the form for things like health insurance and other children that aren't the subject of the proceeding. The most important line on the chart is the overnight visitation credit that the non-custodial parent gets, because it's sort of factored in that if I've got 50-50 custody and the kids are at my house all this time, I'm feeding them, I'm paying for electricity and water, and that gives you a reduction in your support. If you can't come up with your own child support agreement, the court is going to employ the Form 14. So at the end of this whole process, whether you do it by agreement or you have to submit your dispute to the judge to decide, you're going to end up with a judgment of dissolution of marriage, right? That's what we call it in Missouri, dissolving the marriage as a dissolution. It's going to have all the orders related to all of your property and debt division and maintenance. It's going to have a parenting plan that deals with the custody orders and the child support and the division of all those other child-related expenses like health insurance and uncovered medicals and educational expenses and extracurricular expenses and the income tax deductions and all of that good stuff. Does your divorce really end once you have the judgment? We would hope so, right? This is what you finally can see the light at the end of the tunnel. You get your divorce, you move forward, and that's the end of it. We would love to believe that everybody can co-parent peacefully after that, and that's the end of the court process. But unfortunately, there are a lot of contingencies and pending issues that often have to be resolved beyond the judgment stage. Let's say that in the judgment you're awarded half of your wife's pension or 401k. Well, that's got to be accomplished after the divorce is concluded by a qualified domestic relations order. That's an IRS animal, the quadro, that's used to divide your pensions. And unfortunately, that's something that has to occur after the divorce decree. A lot of times in your divorce, you're ordered to do something and you don't do it, right? I get this call all the time. My husband was supposed to refi the mortgage on the house within 6 months. He didn't do it. Or my wife was supposed to execute a gift affidavit to give me the title to my car. She didn't do it. Or my husband was supposed to pay me this equity equalization payment and didn't do it. Well, now you've got to drag your spouse back to court on a motion for contempt because the judge told you to do something, you didn't do it. You got to drag them back into court to say, why didn't you do it? So unfortunately, the divorce process sometimes lasts years and years and years. It's not uncommon for a typical divorce to be concluded within a 1-year period. That's kind of the rule of thumb in courts. It's not something that they advertise, but administratively, the judges get together and say, our rule of thumb is to try to have these cases resolved within 1 year. But a lot of times they linger on for sometimes years afterwards. And I guess the takeaway that I want to offer everybody is that if you don't have a seasoned professional by your side, you're going to get steamrolled because you're not going to know what your rights are. A more savvy attorney like myself is going to take advantage of an unrepresented party. That's not unethical. My job is to represent my client. So if I feel like I can garner an advantage for my client because the unrepresented party is a buffoon or because their attorney doesn't know as much as I'm going to take advantage of that. So I don't have an inspirational or motivational, conclusion to my speech. I'm an attorney, so for me, it's kind of, I hate to sound jaded, but this is what I do for a living. I always tell my clients, you know, if you want to complain about your spouse, I'll be happy to listen to you, but you can do that at a bar to your best friend for free. I'm charging you $4.25 an hour. If you still want to tell me your sad story, I'll be happy to listen. But ultimately, my job is to protect your rights and get you the best financial settlement that's possible. That's how to get to the next level as a client. So sure. Thanks for giving me the opportunity to speak.
Give it up for Tom Karsten. My dad, I'm talking to you again. My dad gives me quotes almost every day. Love my dad. He's at the next level right now. But one of those is, do you feel like you might have doubled your knowledge? Yeah, literally, I mean, how much information did we just get there? And $450 an hour, right? Well, heck, we all should write a check to Tom. That was great information, because this is something you may not go through yourself, but you at least know what you're getting into a little bit more and how you deal with that kind of stuff, so you're prepared for those. That's a big decision. It affects your financial future. And if you're not serious about it, you don't understand that. So I put the song on there, How Do You Like Me Now? How do you like me now? Now that I'm on my way. And how many times we signed up for a deal and then we figured out later it wasn't quite what I was up for. We're going to have another guest speaker here in a little bit. He's going to talk about the other side of that. Sometimes there's ways to repair these things. We're all ultimately just humans, right? Trying to figure out how to get along and how to help each other and how to make it through our life on this little planet for the short time that we're here, right? And so give it up there again for Tom. Doing a great job. Thank you, Tom.